Today we are going to discuss about when to file for request for examination when you're filing a patent in any of the countries. It's a mandatory rule whereby you need to file for request for examination if the company, the startup, the individual wants the application to be granted as a patent. When I talk about request for examination, after the amendment in India, anybody who is entering in the national phase, so national phase application is the basic application is filed in the home country, and within 12 months a PCT application is filed. The full form of PCT is Patent Cooperation Treaty, and that phase of application, when it enters national phase, and the deadline for that is between 28 to 31 months. When we particularly talk about India, the entry has to be within 31 months. It is always advisable to file beforehand, maybe at the 28th or the 29th month in India through the PCT route. Now, after the amendment, the deadline to file the request for examination, which was earlier 48 months, has been reduced to 31 months. Now, what has happened because of it? Now, we should understand one aspect of intellectual property rights is for everything, for every filing, there is a government fees associated with it. If we go through the database and see the number of applications which have been filed in India, either through the PCT route, that is the Patent Cooperation Treaty, or through the Paris Convention, in which you don't need to file for a PCT, but you can enter into any of the countries within 12 months from the first filing date. So what happens is, after the filing is done, irrespective of the fact, it would be published within the expiry of 18 months from the first filing date. So once the publication is done, it is, first of all, it becomes part of the database of that particular country. The important aspect is, once the publication is done, it becomes an arsenal for the company to stop the competitors from filing a similar innovation in that sector. Even if they file, their patent application would be a prior art. So that is called as defensive publication. Now, once the analysis is done, if we take India, for example, there have been multiple times where applications have been filed in the PCT route. However, request for examination is not submitted, which is a strategic point, because once the request for examination is submitted, the examination will happen, then the reply statement will go, then the hearing would be conducted. So there are a couple of steps before the patent is granted. And once the patent is granted, you need to pay a renewal fees on a yearly basis to keep the patent valid. To avoid the expenses associated with the patent grant and the renewal fees, defensive publication becomes a very important arsenal, particularly in the year 2025 and beyond, because now the technological landscape has changed in totality. When we talk about artificial intelligence, we are talking about generative AI and other aspects of the core technical knowledge. The knowledge is changing rapidly, so whether or not to get a patent grant is the question the enterprise needs to answer to understand the landscape. So what is important is to take the steps, have a strategic viewpoint, and see what works for you. What is more important in 2025 and beyond would be the contracts, the agreements between different entities, whether it's in perpetuity, whether it is based on particular goals. Those are the aspects which have to be taken in care in respect of the safeguarding and shielding intellectual property rights.
If you found this helpful, don't forget to like and subscribe for more tips on building a solid business foundation. Until next time, keep growing your empire.